Good morning, ladies and gentlemen. Okay, can everyone hear me at the gels?
Good morning, Judge.
Good morning, how are you?
I'm doing pretty well.
Good. Okay, so I want to welcome everyone to the first appearance court. I want to advise all defendants of some rights that you do have. When I call your case, I need you to step up to the podium, and please understand that you do have the right to remain silent. If you do have anybody here that's here on your behalf, you do have a right to communicate with that person, and that person will have a chance to come up to the microphone and speak on your behalf. You do have right to have an attorney represent you, and if you can't afford one, you'll have the assistance of the public defender. In some cases, if a plea can be offered to resolve your case, I will let you know, and we will resolve your case if you would like. Okay, first person I have is Lauren Camacho.
North Broward, judging judge. She's here at Maine. She was brought from North Broward. I don't know why.
Okay, hi, Ms. Camacho.
Hello.
Now, Ms. Camacho, you're here on a dating violence battery charge. I've reviewed the probable cause affidavit, and I do find probable cause. I am setting bond at $2,500 and ordering no contact with the alleged victim.
Judge, respectfully, in speaking with Ms. Camacho, she's not going to be able to afford the $2,500. My understanding, Judge, is she's been residing in our community her whole entire life. She's 34 years old. She's working. She works at Margaritaville. She's a server. She makes approximately $5 plus tip. My understanding is the alleged victim, she knows that the court's going to order no contact. She's going to abide by that court order. She's going to be living apart with her mother. My understanding is her mother doesn't have much financial resources to post her bond. She is a registered voter in our community. Judge, my understanding, she has very, very limited contact with the criminal justice system. I think one nonviolent drug offense, which she went to drug court and was dismissed. So she adhered to those conditions, Judge. Judge, we're going to be asking you, considering this is a misdemeanor offense, her strong ties to community, for your honor to consider an ROR or in the alternative release her to pretrial release. Besides that request, Judge, we're going to ask you to enter an order so that, as you know, she lives with the alleged victim. She would need access to that property in order to retrieve her personal belongings in order to go ahead and basically survive. So we'd be asking you if she could go via a third party or herself with law enforcement to retrieve that property. So there's two requests, an ROR pretrial and a property order, Judge.
Okay, I understand. State, does Ms. Camacho have any priors?
She has the prior drug offense that she went through drug court on. Your Honor, I don't have an objection if the court were to reduce the bond that you originally set, but I do believe some bond is appropriate considering it's a domestic violence case.
Okay. What I'm going to do, I am going to grant your request to reduce her bond. I'm going to reduce it to $1,000 based upon her priors and the nature of the offense. The court is going to order no contact. Now, I understand you have personal belongings that are at the residence, so the court is going to enter an order allowing you to retrieve the items, but only with law enforcement. You have to contact someone from your closest police department and have a law enforcement officer accompany you.
Thank you, Judge.
You're welcome. Okay. Ernest Frank?
Mr. Frank is here present, Judge.
No, hold on. I give this to you? Yes, sir. How am I supposed to do that? Okay. Hi, Mr. Frank. How are you?
How you doing, ma'am?
I'm well.
Good morning.
Now, Mr. Frank, you're here on a battery charge. I do find probable cause. The court is setting bond at $1,000 and ordering no contact with the alleged victim.
Yes, ma'am.
Okay, you're welcome. Good luck. Vanden Lucien Calito?
Mr. Vanden Calito, I'm mispronouncing his name, Judge.
Vanden Lucien, how do you pronounce your last name? Calito, okay. So Mr. Calito, you're here on a domestic violence battery charge. I do find probable cause. The court is setting bond at $2,500 and ordering no contact with the alleged victim.
Two requests, Judge.
Yes, sir.
Financially, it's reasonable he can afford it. My question is going to be, one, a property order to retrieve his belongings, and number two, a phone order so he can access his phone, so he can contact his other friends and family to post his monetary bond.
Okay. The court is going to grant your request with both issues. I will allow you to retrieve your property, but you must go accompanied by someone from law enforcement, a police officer.
Yes, thank you.
And I will allow you access to your phone.
Thank you so much.
Thank you, Judge.
Good luck. Robert Michael Nieto? Hi, Mr. Nieto.
Good morning, Your Honor.
Good morning. Now, you're here on a violation of probation. There's a no bond hold set, but you're going to be brought before, it looks like, Judge McHugh to deal with your violation of probation warrant.
Judge, is it a violation of pretrial release or is it a violation of an injunction?
It's a violation of probation. It states that he was put on probation for a violation of a pretrial release case, and he allegedly violated probation by picking up an offensive battery, and he had contact with the victim or the victim's family. So,
One month and I paid everything, full cost, and I'm paid off the probation. I don't own anything. Is there anything she can do?
Unfortunately, with the probation, she can't. My question is, Judge, on the docket, we normally have a date here when he's going to be seeing his probation judge. I don't have one here. Does Your Honor know when he's going to be seeing his probation judge?
this is a misdemeanor, so I don't think they have dates for misdemeanors. Madam Clerk, is there a date for court for him? Okay. Judge McHugh does set her own VOP dates, but I would guess to say it's going to be in the next day or two.
Thank you, Judge.
She's on vacation.
Oh, she's on vacation.
Judge Goen does alternate coverage, so.
Okay, I can't give you a direct answer because I don't know the answer, but usually it's done within a week.
Yes, Judge.
All right, good luck, sir. Jennifer Brenner?
I believe Jennifer Brenner's at Paul Ryan, Judge.
Okay, thank you.
Yes, Your Honor.
Oh, hello, Ms. Brenner. Now, Ms. Brenner, you are here on an out-of-state hold from the state of Indiana. There's a no bond hold, but you will be taken to court to address this this matter. Good luck.
Okay.
Sherry Schmidt? Sherry Schmidt?
She's here present, Judge.
Okay. Hello, Ms. Schmidt. Ms. Schmidt, you're also being held on an out-of-state hold from Indiana. Currently, there's a no bond hold, but you will be brought to court to address this matter. Good luck,
Taking it
ma'am.
to district court. They meet on Tuesdays and Thursdays, so probably tomorrow, 1 o'clock, okay? Good luck, ma'am.
Erin Elizabeth Scissors?
Yes.
North Broward, Your Honor.
No problem.
Thank you. Hello, Ms. Scissors.
Hi.
Ms. Scissors, you're here on two capiases, which is a bench warrant on a DUI case. You do have court set on June 11th at 1:30 p.m. to address it. But in the meantime, you do have a $250 bond on
Okay.
each capia, so it's a total of
I feel you, T.
$500.
Elliott.
Okay.
All right.
Judge, these are actually
I
your
definitely
cases.
feel you on that, bro.
And in speaking with Ms. Scissors, she's having some domestic issues, and it's her contention that her husband was not advising her of her court dates, and that's why she did not appear in front of you when she was supposed to. I'd ask the court to consider, and you can do it since it's your case. She does know she has a court date, June 11th, coming up at 1:30 in the afternoon. She has a place to stay, stable residence, and I was wondering if the court might consider allowing her out on pretrial release.
Actually on pretrial release.
And Your Honor, all she had to do was if she wasn't sure when her court date was, all she had to do was contact pretrial. Madam pretrial could advise your clients if they want to know if you can check for a court date, correct?
They contact us.
No, I don't have access to this computer. Can you tell me if she received notice in open court? Because I don't know if
This is a failure to, Your Honor, this is a failure to appear at, arraignment.
Okay, so she did not.
Her court date notice was returned, and 2 weeks after that, she filed a notice of change of address. And that's why I mentioned that this entire time, all she had to do was contact her pretrial release officer that was supervising her.
Okay.
Judge,
so
because she's never been involved,
I'll tell you what I'm going to do. This case is now set. She's going to court in my division on June 11th, regardless.
Yes, ma'am.
Correct? Okay. I'm going to ROR you, Ms. Scissors, on the capiases, and I'm going to see you in my courtroom on June 11th. Make sure you show up
Okay.
at 1:30 p.m. in courtroom
Okay.
6170.
Okay. Can I just make a comment, please?
oh, you won.
No bullshit. Shut the
First
fuck
rule of
up
law
and
school,
roll
when you're
out.
winning, you don't talk anymore.
Your
Yeah, you
attorney
win,
telling
you
you not to
done.
say anything. Don't talk about the facts of the
fuck
case.
outta here,
We'll
bruh.
see you on June 11th.
Yeah, you
and
want to
we
talk
can
and
discuss
shit.
your
Get the
issues at
fuck
that time.
out of here, bro.
Okay, thank you, Your Honor.
You're welcome. Kathleen Marie LaCamera.
Fuck wrong with him, man? The fuck out of here, bro.
Judge, she's here approaching. I just got a call from Mr. from Mr. Gerard McLawrence. He's on his way. If we could put this on recall.
Absolutely. He's representing her?
Correct, Judge.
Okay. Ms. LaCamera, we'll wait for your attorney to get here, and we'll put you on recall for the moment.
He's the city public defender for municipal ordinance case for City of Fort Lauderdale.
I understand.
Thank you, Judge.
Is he ready representing her? I'll put it on recall. We'll see you back in a few minutes.
Hey, Nate, you
Lauren
feel me, bro?
Sharia Phelps?
North Broward.
Thank you.
Yes.
Ms. Phelps would like to resolve this matter today if possible, Your
Okay,
Honor.
hello, Ms. Phelps.
How you doing, ma'am?
I'm well, thank you for asking. Ms. Phelps, you're here on a capias for a missed court date in a petty theft case. There is currently a $1,000 bond, but the public defender's office is indicating you'd like to resolve your case today. Is that correct?
Yes, ma'am.
Okay. So can the state make a plea offer for Ms. Phelps?
Yes, ma'am. The state's offer to be an adjudication, time served, no return to the target at 3599 West Hillsborough Boulevard in Deerfield.
Is that what you'd like to do, Ms. Phelps? It would be an adjudication, time served, and as we talked about it, you get a third petty theft, it could be a felony. You understand that?
Yes, sir.
Do you want to accept the state's offer of an adjudication and time served?
Yes.
Okay, there's also no return to the subject target. Ma'am, you understand?
Yes, ma'am.
Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, put your hand down. You advise the court you'd like to resolve your case today. Is that correct?
Yes.
And the court's going to adjudicate you guilty, sentence you to time served, and order no return to the subject target. Is that your understanding?
Yes, ma'am.
Now, by resolving your case, you're waiving certain rights you have, including your right to have a trial and to require the state to prove the case beyond a reasonable doubt. You understand? I can't hear you.
Yes, ma'am. Could I speak with my public defender on the phone?
No.
Is there a way that you could? Okay.
Do you need to talk to me, Ms. Phelps?
Yes, I
Okay,
just want
all
to
right,
make
I'll call you right now.
Okay.
I'll call the next case in the meantime. I'll call the next case. Okay, I'll put Ms. Phelps on recall. Erin Rose Emmerling? Hi, Ms. Emmerling.
Hi.
Now, Ms. Emmerling, you're here on a possession of heroin charge, and then you have 2 violation of probation warrants. The court does find probable cause, and you have a $1,000 bond on the heroin charge. There's no bond hold on the violation of probation warrants, but you go into court on June 11th at 9 a.m. to address them.
Okay.
Good luck.
Thank you.
You're welcome. Anne Marie Hall?
She's here at Main, Judge. She is approaching.
Okay, thank you. Hello, Ms. Hall.
Hi.
Ms. Hall, you're here on a possession of cocaine charge. The court does find probable cause. You have bond set at $1,000.
Judge, and speaking of Ms. Hall, that's something that she's not going to be able to come up with now. When she was arrested, I believe she has $140 in her property. My understanding, I believe that the jail takes out about $23 a day, so maybe she has probably around $115. So I'd be asking you either to reduce her bond to $100 or to consider releasing her on pretrial release. She's 55 years old, been living here her whole entire life. She's on disability. She lives by herself as she receives the assistance of housing. So therefore, there's really nobody that can help her post her monetary bond. Considering this is a non-violent offense, I'd ask you either to consider pretrial release or to reducing her bond to $100.
Okay. Madam Pretrial, is she eligible for pretrial release?
If the court orders us to take her.
Okay, and what's the state's position?
Your Honor, as far as pretrial release, just so the court's aware, she was arrested last month on a failure to appear on a municipal ordinance. She has another prior failure to appear. She's been to state prison, 4 prior felony convictions, 5 prior misdemeanor convictions.
Okay, ma'am, if I put you on pretrial release, you're going to need to report to pretrial release, and you're going to need to show up in court.
Okay.
If you don't show up to pretrial release, and you don't show up in court, your pretrial release could very well be revoked, and you'd be back in jail.
Okay.
Do you understand?
I know. Yes.
Okay, I am going to refer Ms. Hall to pretrial release.
Thank you, Judge.
And
You
you
have
submit
to
to a
report
drug
within 24
evaluation
hours.
on random urinalyses?
Yes, the court's going to order, Ms. Hall, that you're going to submit to random
Nah, that's a
drug
felony,
testing.
bro.
Okay.
She can't.
All
She
right.
can't get no.
Your Honor, we can recall Ms.
The
Phelps. at North Broward
$1,000
if you
is
like.
already $100 bond anyway. You gotta pay 10% of that shit, bro. $1,000 is
All
already
right, so
$100,
recall
bro.
on Ms. Phelps in North Broward. Okay, Ms. Phelps,
But
what
that's
would
a
you like to
felony.
do?
Cocaine is a felony.
That's fine what you said.
You want to resolve your case today?
Yes.
Okay, so I want to remind you, you're still under oath. And you understand by resolving your case today, you're waiving your right to have a trial and require the state to prove the case beyond a reasonable doubt?
Yes.
You also are waiving your right to have an attorney represent you, and if you can't afford one, one would be appointed. You understand?
Yes, ma'am.
Okay. And how do you plea, Ms. Phelps?
No contest.
The court
Willie
will accept
Thompson,
your plea
what's
of no
good, bro?
contest. The court's going to adjudicate you guilty, sentence
know
you to
what's
time
got-
served, and order no return to the subject target. All right. You're all
Whole lot
set
of
now.
weed and bond hearings.
Thank
Remember
you.
what we
Thank
said.
you. Okay, thank you guys.
You're welcome. Samantha Raymond?
No problem.
Raymond, hi. She on behalf of confinement status. Count 2 is an AF warrant, and the warrant is a no bond hold, and I believe the finding says $1,000.
Okay, so I was looking in the 2 counts of grand theft. There's 1 arrest warrant, and, hold on, these are 2 different arrest warrants?
No, Your Honor,
Yes.
if I may, the original arrest warrant was for the actual taking of the vehicle. When law enforcement encountered Ms. Raymond yesterday, she was still in possession of the vehicle, so he charged her with grand theft for still being in possession of the stolen vehicle.
GL don't fuck with
So
Mo
she's
Wash
being
Battle
charged
League
with
no
grand
more.
theft of being in possession of the same vehicle? 2
Yes,
charges.
it's because
Cause
they're
Amber
separated
Deck,
by over a
strong
month.
neck,
The
strong
alleged
braid,
actual
rough
taking of the
ass
vehicle occurred on May
fucking
1st.
Happy
So I
Meal
believe
toy
since it's
face
separated
ass
by,
motherfucker. Fuck
kind of
out of
possession
here.
of,
No.
the
No
stolen
more wash, bruh.
Vehicle can still constitute a grand theft auto.
Okay. All right, so Miss Raymond, you have bond set at $2,000.
Yes, ma'am.
All right, good luck to you.
No, Judge. So you're setting count 2 as a no bond, you're setting me that $1,000? It was booked wrong.
The judge said no bond, but frankly, Judge, $1,000 is a standard bond for a grand theft auto. I don't have an objection.
Okay, I'm going to keep the bonds at $1,000 on each, so it's $2,000 total.
Samantha, I'll call your friend for you, okay?
Thank you.
James Dewey Rayner? Where's Mr. Dewey Rayner? Is James,
It says me in jail.
okay, James Dewey Rayner?
Judge, Judge, he's approaching. He's here at Maine.
Okay. Mr. Rayner, you're here on 2 cases for missing court, misdemeanor court. You have a failure to register capias and a suspended license capias. Does the court have a driving record for Mr. Rayner? I'm going to see if we can resolve your cases today if you'd like.
Yes, thank you, Judge. That's what he wanted me to ask the court.
Okay. All right, let me take a look at your driving record, sir. Oh, this is not him. Okay, he doesn't have a... Yeah, no, you gave me the right record, but he doesn't have a driver's license.
Yes.
Does the state have any different information?
No, one moment here. Yeah, he's never had a driver's license in the state of Florida.
But I don't even see any suspensions on his driving record.
One moment.
It looks like it would be a no valid license instead of a suspended license.
Willie, I'm going to be honest with you. Moses kicked me out of Mowash Battle League group because of Amber Deck saying kick me out the group because of their Queen in the Ring battle, and I was blowing too much smoke at her and a couple of other motherfucking battlers like Ebony Guzman, motherfucking YS in the face ass bitch, man. Like, she motherfucking got mad. They kept making posts and shit talking about kick GL out the group and all this other wild ass shit. So Moses like, all right, GL kicked out the group until September the 30th after their battle. I was like, that's some sucker shit. Fuck out of here. Nope, I'm not doing no Florida shit. I'm on strike.
First appearance, Your Honor, because basically, Judge, what I've seen, and this happened in the past, is that yes, everything in the system looks a certain way, and then something comes to light after. I don't have a problem in light of, Your Honor, frankly, I don't have a problem in light of this. If the court were even inclined to ROR him and then let it work itself out, you can go back to court.
Okay, I'll tell you what, Mr. Rayner. It looks like you possibly have an incorrect charge. So what I'm going to do, I'm going to ROR you on these capias matters, let you go to court, and let the prosecutor in that court address your case.
Thank you, Judge.
You're welcome. John Hackett.
Mr. Hackett is here present. He is approaching, Judge. These are municipal ordinance cases.
Yes.
I'm sorry.
Hello, sir.
Good morning, Judge. How are you?
Well, Mr. Hackett, you're here on 2 capiases for municipal violations. One is open container, and the other one is sleeping in public. Would you like to resolve your case today?
Yes, ma'am. I would love to.
All right. State, can you tell me if Mr. Hackett, what kind of priors he has, if any? I just want to know his priors.
What's his name, Your Honor?
John Hackett.
Trespass 2016 on a adjudication. Aaron back came. And then today's case is what I see out of the state of Florida.
Okay, thank you.
You're welcome.
Everybody always wants you to pull up, like they don't walk to the corner store or something. Get the fuck out of here, bro.
On each of your cases.
Yes, ma'am.
Okay, raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. So you put your hand down. You've advised the court you'd like to resolve both of your city ordinance violations. Is that correct?
Yes, ma'am.
Okay. And in case 173612 MO40A, which is the open container charge, how do you plead?
No contest, Your Honor.
Court's going to accept your plea of no contest. The court's going to adjudicate you guilty, sentence you to time served. In case 17882 MO10A, I'm sorry, no, it's 173812 MO40A, which is the sleeping in the street charge, how do you plead?
No contest, ma'am.
The court will accept your plea of no contest. The court's going to adjudicate you guilty and sentence you to time served. You're all set, Mr. Hackett.
Thank you very much, Judge.
You're welcome.
Go over here.
Yes. Juan Brito Contreras.
Judge, Mr. Contreras is here present, Judge, at Maine, or he's going to require a Spanish interpreter.
Okay, we'll order the interpreter. We'll put him on recall. Okay, Madam Clerk, can you call the Spanish interpreter? The PD does. Okay. David Robert Johnson?
I believe North Broward.
He's in North Broward, Your Honor.
Thank you. Hi, Mr. Johnson.
How you doing?
I'm well, thank you. Mr. Johnson, you're here on a capious and a trespass case. Would you like to resolve your case today?
Yes, I would.
Okay, Mr. Linder, I'd like for you to make a plea offer for David Johnson on his trespass case, please.
No, Your Honor. State's offer will be one moment, sorry, Judge. Yes. I've got to check, Your Honor. I know it says, oh, Your Honor, this, I'm trying to figure out if this is in
This is Judge Lerner Wren.
if it's in her regular division or her mental health.
It's not in her regular division.
Okay, then
So
I
it's-
wouldn't
okay.
have an offer, Your Honor.
All right, so Mr. Johnson, at this point in time, the court can't resolve your case. You do have a $250 bond, and you're going to go back to see Judge Lerner Wren.
Yes, ma'am.
Okay, good luck to you, sir.
Okay. Hang in there, David.
Lampus Hooks. Lampus Hooks. If Lampus Hooks is here, come on up. Okay, there you are. Hello, Mr.
Mr.
Hooks.
Hooks is here present. It's a municipal ordinance case.
Yes, Mr. Hooks, you're here on a alcoholic open container charge, which is a municipal ordinance violation. The court does find probable cause. Would you like to resolve your case? Okay. Patrice, can you tell me what priors he has?
I see an 85 alcohol beverage violation adjudicated. 2001, there was a sale of cocaine that was subsequently dropped. 2010, battery on an officer, also dropped, Your Honor.
All right. Mr. Hooks, if you'd like to resolve your case, the court will offer you a withhold adjudication and court cost, meaning it's not a conviction. Do you want to do that?
I hear you.
If you'd like to resolve your case, the court will offer you a withhold adjudication and court cost, meaning it's not a conviction on your record.
Okay.
All right, let me have you raise your right hand. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Why is it so loud? Whose mic is...
You're getting noise back from the main jail.
Oh, okay. All right. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, put your hand down. Mr. Hooks, you've advised the court you'd like to resolve your case today, is that correct? You'd like to resolve your case today, is that correct?
Yes,
Okay.
ma'am.
How do you plead on the open container charge?
No contest.
The court will accept your plea of no contest. The court will withhold adjudication, impose court costs, and you're all set. Good luck. Willis Augustin Fort Farrow.
Mr. Achilles Farrow is here present, Judge. I think he is approaching.
Okay, thank you. Hi, Mr. Farrow. Well, thank you. Mr. Farrow, you're here on a battery charge. The court does find probable cause. You have a $1,000 bond, and the court is ordering no contact with the alleged victim. Good luck, sir.
Thank you. He advised me that his mother will be posting his bond, so I have no request at this time.
Okay, good luck, Mr. Farrow. David Charles Stevens.
Mr. Stevens is here present, Judge?
Judge, if I could just
there's
have a
Mr.
moment to speak with
McLaurin.
Mr. Stevens. Yes.
Okay, I also
just
have
need 1 moment.
I also have a Kathleen LaCamera that you need to speak with.
I spoke with her, Judge.
Okay.
She's here, Your Honor. She's on page 5 of the docket.
Yeah.
She's here with me. I spoke with her.
Okay.
She's here on a municipal.
I'm sorry.
She's here on a city. I'm sorry. Okay.
Good morning, Judge.
Hi again,
She's
Ms.
here on the
LaCamera.
City of Fort Lauderdale possession of drug paraphernalia municipal ordinance. And Judge, I spoke to her about this matter. She told me she just wants to resolve it. She intends on going to the hack to get some assistance.
Okay.
So I'm asking the court with adjudicating time server.
Okay. What kind of priors does she have?
Let's see. Here I have to, it's gonna take me a few minutes to go through. I show over 43 arrests. So I'll start at most recent.
Yeah, just start at the most recent.
Yeah. 2016, there was a grand theft. State, is that open?
I know.
There was an adjudication for a petty theft in 2014. There was a 2012 grand theft adjudication. 2010 possession of cocaine adjudication. 2010 violation of probation. Possession of cocaine from 2010. I show a failing to appear during the pendency of that case at least 3 times. 2002 sale of cocaine. She violated her probation. Failed to appear a couple times there also.
Okay, Mr. McLaurin, the court's not comfortable with offering an adjudication and time served on the case.
Damn.
She has a $250 bond.
Right, Judge, and she can't make that $250 bond. She's homeless.
You can't make $25?
She would just be stuck here on $250. Even if you reduce it to $25,
that's what it is.
She'd still be stuck here, Judge. So I'm asking if, Judge, I think her last offense was 2012 or something like that?
No, it wasn't. It was 2016.
16?
Yeah.
Right.
The court would offer her an adjudication and 10 days in jail.
Okay, Judge, we'll just keep the bond then, Judge. I'll resolve it in case, in court.
All right.
Thank you, Judge.
She's going to court on June 8th, which is Friday.
Okay, thank you, Judge.
All right, and let me know when you're ready on Mr. Stevens.
Okay.
Dane Orlando Josephs.
Yeah, medical reset, Your Honor.
Okay, we'll reset him for tomorrow. Ricky Lee Phillips.
Mr. Phillips is approaching, Judge. He's here at me.
Hi, Mr. Phillips. Mr. Phillips, you're here on a petty theft charge. The court does find probable cause. Would you like to resolve your case today?
Yes, Judge.
Okay. What's the state's plea offer for Ricky Lee Phillips?
1 moment, Judge. Your Honor, state's offer would be 15 days, Your Honor. His criminal history, 2015, resisting with violence, 2 years state prison as a habitual offender. 2015, failure to register as a career offender, 2 years state prison as a habitual offender. Possession of cocaine, 2013. Felony theft, 2011, 17 and a half months state prison. Grand theft, 2011, 17 and a half months. Felony theft, 08, 22 and a half months. 07, failure to register as career offender, 22 months habitual offender. Felony theft, 07, 22 and a half months. Possession of cocaine, 06. Grand theft auto, 05, a year and a day state prison as a habitual offender. Theft, 06. Bat Leo, it goes on from there.
Okay. All right, if you'd like to resolve his case, the offer from the state's an adjudication, 15 days in the Broward County Jail. And the court would order no return to the subject property.
I don't think Mr. Phillips is going to have a problem adhering to the order as far as no return. Unfortunately, Mr. Phillips is homeless, but however, he does want me to ask the court, he wants to resolve this case. My understanding is that this took place at a Walmart. I believe
yes.
The merchandise was recovered. I believe the item in question may have been like under $40 in value. Considering
yes.
that, Judge, I'd ask you if the court would consider 5 days. 5 days.
Based upon his prior criminal record, the court's going to go along with the state's offer.
Understood. Let me just have 1 second to speak, Mr. Phillips.
Okay.
Your Honor?
Yes. Sure.
Judge, he wishes to accept the state's offer.
Okay. Raise your right hand, Mr. Phillips. You swear or affirm to tell the truth, the whole truth, and nothing but the truth? Sir?
Yes, ma'am.
Okay, put your hand down. Mr. Phillips, you've advised the court you'd like to resolve your case today. The court's going to adjudicate you guilty, sentence you to 15 days in the Broward County Jail, order no return to the subject Walmart. Is that your understanding?
Yes, ma'am.
Okay. And by resolving your case, you're waiving your right to have a trial and to require the state to prove the case beyond a reasonable doubt. You understand?
Yes, ma'am.
Okay. And tell me how you plea, Mr. Phillips.
No contest.
Court's going to accept your plea of no contest. Court's going to adjudicate you guilty, impose costs, sentence you to 15 days in the Broward County Jail, and order no return to the subject Walmart. All right, good luck to you in the future, Mr. Phillips.
Our Spanish interpreter is here, Judge.
And the case is Terrence Fallon on page 22.
Okay, is that towards the end of the
Yes.
Hi, hold on, let me find your client. Is that towards the end?
Yes.
Terrence
Fallon, F-A-L-L-O-N.
Okay, let me find him here. I have him here. Okay. All right. Terrence Fallon? Is Terrence Fallon here?
Checking to make sure he's...
It says Rain Jail.
Oh, is that him? Yes. Okay. Hello, Mr. Fallon. Okay, we can hear you now. Okay, so Mr. Fallon, you have your attorney here and, ma'am, his wife. Your wife is here as well. Okay, you're here on an aggravated assault with the intent to commit a felony charge. The court does find probable cause. I can't hear you.
Your Honor, I've spoken with the state. We have an agreement in place regarding that.
Tell me.
It's going to be $50,000.
50?
Yes.
Okay.
Kesha
Yes.
Davidson for the state. No victim contact as well. No firearms or ammunition.
Okay. So, Mr. Fallon, the state and your attorney have agreed to bond to be set in the amount of $50,000. You are not to possess any firearms. Why am I having such bad trouble hearing?
If Mr. Fallon could hit the button again, he'll be able to hear us. We just won't hear the noise coming from the jail.
Oh, that's much better. Thank you. Can you hear me, Mr. Fallon? But now I can't hear him.
I can't hear him.
Yes.
Okay, if everybody that's in the back could quiet down a little, I'm having trouble speaking with Mr. Fallon. Okay, so Mr. Fallon, the bond is set at $50,000. You're to have no contact with the alleged victim, and you are not to possess any firearms or weapons. And you have your attorney here that will be representing you. All right.
Okay.
Terrence, we'll talk when you get out. Okay?
All right. Good luck, Mr. Fallon. You're welcome.
Thank you. Mr. Fallon? Judge, could I recall David Stevens?
Yes.
He's on page 9 of the docket, Your Honor.
Yes. Mr. Stevens, hello.
Good morning, Judge.
Now, Mr. Stevens, you're here on 2 municipal violations. One is a possession of drug paraphernalia. The other is open container. Would he like to resolve his cases?
Yes, Judge, he does.
Okay, and Patrice, could you tell me what kind of priors Mr. Stevens has?
Judge, could you please not announce his priors?
Right, I'm not saying it out loud.
Thank you.
Oh.
I'm muted my mic.
Okay, okay.
Yeah. He does have some other DUIs and things like that, but I believe that's what he didn't want to be announced out loud.
Okay.
So if you want me to put the rest on the record, I should.
Yeah, do that.
So apart from what I've already told the court, I see where he had a liquor violation in 2015. He was adjudicated. Another in 2014. A third in 2014. Possession of a controlled substance in 2014. He was adjudicated on that. And those particular priors are out of the state of Texas.
Okay.
There are other priors, Your Honor, but based on what I've already told you and that, I think we can stop there.
Okay. All right, so Mr. Stevens, if you'd like to resolve your case, you have multiple priors for the same charge. The court will offer you an adjudication and 5 days in the Broward County Jail.
You're going to be here longer. There's a 30-day program.
Yes, sir.
The only thing I would request is that, and I only bring this up, I know the charges before the court are municipal ordinances, but there could be other effects of him taking this plea that the state would be involved in, namely that he could face potential civil commitment. So I'm just asking, it's up to him, I'm just asking if the court could advise him of that.
Okay, okay. So, Mr. Stevens, based upon your priors, if you resolve this case, you may be subject to civil commitment by the state. And if you'd like to speak with your attorney about what that means, I will let you speak with your attorney in private.
Judge, if we could just place it on brief recall again, Your Honor.
You got it. Okay.
Our Spanish interpreter is here, Your Honor.
Okay, recall on Juan Brito Contreras. Hello, Madam Interpreter. How are you?
Morning.
Good, good morning. Madam Interpreter, raise your right hand. You swear or affirm to translate from English to Spanish and Spanish to English to the best of your ability?
I do. Maria Salazar, Certified Court Interpreter.
Thank you. Now, Mr. Contreras, you're here on a trespass charge.
Señor Quinteros, usted está acá en un caso de entrada prohibida.
The court does find probable cause.
La Corte encuentra que hay causa probable.
Would you like to resolve your case today?
¿Usted quiere resolver su caso hoy?
Judge, respectfully, in speaking with Mr. Contreras, we were going to be asking the court to consider releasing him on his own recognizance.
Su abogado le pide a la señora jueza que le dé la libertad bajo palabra.
Considering this is a misdemeanor nonviolent charge, I don't know if the state has an objection to an outright ROR on Mr. Contreras' behalf.
Considerando que este es un delito menor, están pidiendo si la fiscalía le puede dar la libertad bajo palabra.
Does the state have any objection?
I don't have a problem as long as he doesn't go back to this Home Depot.
No tiene problema el fiscal de la libertad bajo palabra siempre y cuando usted no regrese a ese Home Depot.
Okay, Mr. Quinteros, the court is going to ROR you.
Señor Quinteros, la corte le va a dar la libertad bajo palabra.
But please, while this case is pending, do not go back to the subject Home Depot.
Pero, por favor, mientras este caso esté pendiente, usted, por favor, no regrese a ese Home Depot.
And just so you know, you have a court date on June 11th at 2 p.m.
Y solamente para que sepa, junio 11 a las 12 de la tarde, usted tiene otra fecha acá en la corte. Otra fecha para venir a la corte.
Let me write it down so we make sure not to miss it.
Y se lo van a escribir.
June 11th, 2 p.m.
June
Junio
11th.
11, 2 de la tarde.
And what courtroom number?
¿En qué sala?
It's Division MT, I believe, which is... So why does it say status?
It's probably erroneous because it's a new arrest warrant.
But why would it say status?
You might have just been a mistake.
Yeah, I am. It says it's got a status date.
It might have just been done in error.
Okay, all right, Mr. Quinteros, I've been advised that the court date's in error. You will get notice in the mail.
Señor Quintero, se me acaba de hacer saber de que esa fecha que le han dado de la corte está errada y que va a recibir usted una notificación por correo con la fecha.
Thank you, Judge.
You're welcome. And Madam Interpreter, could you ask if anyone else needs your assistance?
¿Alguien más necesita la intérprete?
Let me inquire, Judge.
Okay.
Judge, nobody else at Maine requires Spanish interpreter. I don't know if the other facilities do, however.
I don't believe anyone at North Broward does, Judge, and I don't think we have anyone at Paul Ryan, and the person in Conti does not require a Spanish interpreter.
All right, thank you very much. Thank you for your help, Madam Interpreter.
You're welcome, Your Honor. Have a nice day.
You too. Kevin Lavetta Jackson?
Medical reset.
Okay, we'll set him for...
Kevin Jackson on page 10.
Jackson. Eddie Rancher?
Medical reset, Judge.
All right, we'll reset him for tomorrow.
Judge, I'm ready on David Stevens, Your Honor.
Okay, recall on David Charles Stevens. Yes.
Judge, I explained the offer to him. I also explained about the Jimmy Rice consequences or possibility, and he's agreed that he's going to accept the 5 days offer, Judge.
Okay. Mr. Stevens, raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Judge.
Okay. Now, your attorneys advised the court that you'd like to resolve your case today. Is that correct?
Yes, Judge.
On the court, on the possession of drug paraphernalia and the open container violation, is going to adjudicate you guilty, sentence you to 5 days in the Broward County Jail to run concurrent. So it's 5 days total. Is that your understanding?
Yes, Judge.
Okay. Have you had enough time to speak with your attorney about resolving this case?
I have.
And you understand that based upon your priors, you may be subject to a civil commitment by the state under the Jimmy Rice Act?
I understand I'm subject to it, but I really don't understand why. But I guess I just can't get into that here. But
Well, you don't have to resolve your case, because I don't want...
No, I would like to resolve the case.
Okay, but do you understand what I just said?
Yes.
Okay. Has anybody forced you into entering the plea?
No.
How do you plea, Mr. Stevens?
No contest.
Court's going to accept your plea of no contest. Court's going to adjudicate you guilty, impose costs, sentence you to 5 days in the Broward County Jail on count 1, adjudicate you guilty, impose costs, sentence you to 5 days in the Broward County Jail on count 2 to run concurrent.
Judge, just one request.
Yes, sir.
Would the court enter an order allowing Mr. Stevens access to his phone so he could get his brother's phone number to inform his brother that he's in custody?
Yes.
Okay, thank you,
I can,
Judge.
but
I'll be
he's
up
gonna
in your courtroom and I'll fill out the order.
Yeah, he's going to be released.
Okay.
I'm sorry, he's going to be released in 5 days.
Yes, Judge.
Okay, all right. You could have access to your phone.
Thank you, Judge.
Edgar Chang?
Yes, good morning.
Mr. Chang is in North Broward, Your Honor. I'm going to be asking for pretrial release on Mr. Chang's case.
Hello, Mr. Chang.
Morning.
Mr. Chang, you are here on a capias in a felony matter, currently there's a $1,000 bond set, and it looks like this is an ad charge. Okay, for a grand theft. And counsel, why are you asking for pretrial?
Mr. Chang has indicated to me, Your Honor, he was in custody when this capias was issued. He is currently on pretrial release on the other charges.
Okay.
The only count holding him in custody is this grand theft at this time.
Okay. Does the state have any objection to having Mr. Chang placed on pretrial release
I
on
don't
this
have a
ad
problem with
charge?
that. I just want to know for the record, it's not, he was in custody. This was not in custody capias. It wasn't as though, you know, it was from a failure to appear in court that he couldn't go to because he was in custody. I'm just clarifying for record purposes. But
Okay.
that being said, I have no objection to pretrial.
Okay. The court's going to grant your attorney's request. I'm going to refer you to pretrial, which you're already on your other counts.
Okay.
All right, so you're all set.
June 12th, 9 a.m., Edgar. Okay?
Yes, I have a question. Do I go to pretrial or do they come to me?
You go to them. They'll hand you a map right now.
All right.
All right, good luck.
Thank you, Deputy.
Pete Reynard Peterman?
Just so
Hold on 1 second, sir.
Hold on, Edgar.
I have an order here. He's being placed on an electronic monitor.
Okay.
Those are the conditions of his pretrial?
The prior, one of the charges that he has here is for a DUI second. And so he's going to be affixed with a TAD monitor. So they'll come to him.
Okay, so they're going to put a monitor on you, Edgar. You cannot drink
Hold on
or the
1
monitor will
second.
go off.
Hold on. Apparently that was changed in the division.
1 moment.
So they're gonna come to me.
We're going to let you know in 1 moment.
Okay.
It was changed to standard.
Oh, okay.
Okay, no monitor. You go to them.
Okay.
All right.
Okay.
Follow the map.
Pete Peterman?
Copy.
Hi, Mr. Peterman.
Yes, good morning, Your Honor.
Mr. Peterman, you're here on some ad charges, burglary of an unoccupied conveyance, grand theft, illegal use of a credit card, and fraudulent use without consent. The court does find probable cause. The court's setting bond on the burglary charge in the amount of $1,000, and bond is set on the other charges in the amount of $5,500. So you have a total of $6,500 in bond.
And Mr. Peterman has some no bond holds on him, Judge, so he'll need to resolve that in front of his division judge.
Okay.
Yeah.
Judge, I'm sorry, so count 9 is 1,000?
Yes.
And then count 10, 11, and 12. Can you state the counts in the bond, please?
Yes. Count 10, grand theft, 1,000. Count 11, the illegal use of a credit card, 1,000. And count 12, the fraudulent use, 3,500. You're welcome. All right, you'll deal with, you have a no bond hold right now, so you have to deal with that case.
Okay, but ma'am,
Yes.
with the added charge, they added the charge, and I was out on pretrial. I was out on pretrial, and Court Spring came back and gave me 2 more charges that took my bond. I was asking, ma'am, if I'm on pretrial, and I haven't been in no trouble since 2011. I have no failure to appear. I have no my cases hasn't been assigned to no judge yet, and I got ties with the community. Is there any possible way, ma'am, I can get my pretrial back, because I didn't even commit another crime? All these was added crimes.
Okay, sir, let me advise you. You're being held on other charges that have a no bond hold. This court cannot change that status. You have to go to the trial division, the trial court, and address that issue with the trial court.
Yeah, but the no bond hold, ma'am, was given to me in magistrate. I don't even have a division judge. I understand if I had a division judge that you guys couldn't make that decision, but being that the magistrate judge gave me a no bond hold on the pretrial, I was wondering, can you look over my background, ma'am? I haven't been in any trouble, and I'm sitting here, and the things that I need to figure out about my case, I only have my mom. She's over 70, and I need to really get out to help my public defender.
Okay.
I haven't been in any trouble, ma'am. Like, these charges, if you look at my record, I never in my history had these type of charges. These charges stipulated from something that I have no clue that I'm trying to fix. And by me just sitting in jail and I burned it out and they came back to pick me up, I can't help myself.
Does he have
never
had
no failure to peers.
I hear what I hear what you're saying. Let me find out some information. Does he have a court date? State?
One moment.
We're gonna find out if you have a division judge and if you have a court date, sir.
On these new charges or the charges?
No, the no bond.
Division judge appears to be Dennis Bailey.
Yeah,
The one he's being held on a no bond hold.
Yes, and a date hasn't been set. I have. It looks like he has no attorney representing him at this point. I don't know if he's filled out paperwork or.
Well, he does on one of the cases.
I'm just on this case. There's no attorney representing him.
On the 1800-5813 case, he has a public defender representing him. It looks like we were just appointed last week, and we have filed a demand for discovery. That's as far as I can tell right now. Mr. Peterman, has anyone been to see you in the jail?
No, sir, and I know you guys kind of backed up.
Yeah, and I'm going to take care of that for you, Mr. Peterman. I'm going to have somebody out to see you ASAP.
And I done completed pre-trial before I completed probation.
I know, but there's nothing that Judge Levy can do about the no bond holds this morning because they're not even in front of her.
Mr. Peterman, let me tell you what's going to happen. You do have the public defender on one of your cases. The public defender's office is going to go out to see you to talk about your cases and how they could help you. But this court can't address your no bond hold. You have a division judge. It's Judge Tim Bailey.
Do I have a court date yet?
Does not appear as though a court date has been set.
But you have an attorney, so we'll get that taken care of. I'm sorry, sir.
Good luck, Mr. Peterman. I'll be taking a look at it.
Nathan Lee Cole?
Mr. Cole declined our invitation to appear, Your Honor.
Okay, so I will reset him for tomorrow because this is the first time that he's been up.
Actually, Judge, he has been here before. He
These
has
are
a
add
number
charges.
of prior charges.
I think it's reasonable to give one. He hasn't been here on these before.
All right.
Right, these are add
okay,
charges.
that's fine.
I don't want to magistrate him in absentia, give him another chance to
Okay.
come in tomorrow. Okay. David George Prim? Hi, Mr. Prim. Mr. Prim, you're here on a possession of cocaine charge and a felony suspended license. The court does find probable cause. You have bond set at $1,750.
Judge, unfortunately, Mr. Prim's not going to be able to afford that. He's 52 years old, been in Florida his whole life. Right now, he's employed. He works for a company called GAF Equipment. He's a mechanic. He lives in Davie with his family. His father is basically retired, so from what he advised me, financially, he can't really afford to post his bond. Mr. Prim does have a record. However, Judge, this is a nonviolent offense, so we'd be asking you to consider releasing him on pretrial release.
Okay. Does the state have any objection to releasing Mr. Prim on pretrial?
The state objects, Your Honor, based on his priors. He has a 2014 dealing in stolen property, 2014 aggravated 45 months state prison. He has a 2014 aggravated fleeing, 45 months state prison, 2013 burglary, structure unoccupied, 45 months in state prison. He has a possession of cocaine, he got time served. He has a 2008 battery, 207 days.
Okay. The court is not going to refer him to pretrial.
Judge, in the alternative, I mean, even though his father's retired, he's going to try and come up with something. I don't think he can come up with much, would you at least consider count 2 ROR? He does have a job. If he's not able to bond out, he's going to lose his job. It's going to have a spiral effect. Yes, he has a record, but my understanding is, as you heard, it's not an egregious as far as violent offenses, Judge. This is a non-violent offense, so we'd ask you at the very least then to consider an ROR on count 2.
Okay, the court is going to deny that request. I'm going to leave bond set at $1,750.
Yes, Judge.
Scotty Cambrell Miller.
Mr. Miller's approaching.
Okay, hello, Mr. Miller.
How you doing, man?
Well, Mr. Miller, you're here on a robbery charge. The court does find probable cause. I am setting bond in the amount of $2,500 and ordering no contact with the alleged victim.
Yes, Judge.
All right. Wilson Soto.
Mr. Soto?
Hello, Mr. Soto.
Hello.
Mr. Soto, you're here on, you have a capias from a felony case and a capias from a misdemeanor case. You have a $500 bond on the misdemeanor, but there's a no bond hold on the felony capiases. You're going to go to court to address those matters.
Good luck, sir.
Bryant Jean Pierre.
Judge, I've been advised he's in regular court.
Mr. Jean Pierre's in regular court. Okay. Okay. I'm sorry, Mr. Linder?
Oh,
No.
it shouldn't even be here for,
Yeah.
it's a no bond hold, Your Honor, and that's not capacity. It shouldn't have even been.
I believe.
Jean Pierre is a VOP, so he's gonna go to division. He was removed from the docket.
Okay, then I will just hand this over. Gregory Hayes.
Mr. Hayes, come on up, please.
Hello, Mr. Hayes.
Good morning.
Mr. Hayes, you're here on a violation of probation. You have a dealing in stolen property, false ownership, info for pawned items, and a grand theft charge in which there was an arrest warrant issued. Right now, you have a bond on the dealing in stolen property, false ownership, info for pawned items, and grand theft in the amount of $5,500. There's a no bond hold on your violation of probation, but you do have a court date on June 12th at 8:30 a.m. to address it. So good luck, sir.
What's your, okay.
Daniel Reed?
Your Honor, Mr. Reed's sister is here on his behalf.
Okay. Hello. Hello, ma'am.
Hello, how you doing?
I'm well. And who's this with you?
Jasmine, and this is Anthony, my son.
Hello, Anthony. Okay, Mr. Reed, how are you?
All right, ma'am.
You have your sister Jasmine here and her son Anthony, and you're being held on a violation of parole. Currently, there's a no bond hold. And does he have a court date?
Your Honor, no, he's just gonna have to go before the parole board. They'll come down here and see him.
Okay.
It's actually outside the jurisdiction of any of the courts here.
Okay. All right. So right now he's being held to address the violation of parole. Is there anything that you'd like to say, Jasmine?
He can call me. I put money on my card, so he can call me.
Okay.
He was trying to call yesterday, but I couldn't get to the store fast enough.
Okay. So your sister says that you could call her now if you'd like to speak with her.
Judge, just one message. My understanding is Mr. Reed has property. He's going to voucher his property out to her so she could come to the jail and recover his property.
Okay. You got that, Jasmine?
Okay.
All right. Good luck, sir. Good luck.
So I just go.
You could go to the jail and pick up his property.
No, not today.
Not tomorrow. Okay. Benjamin Stroman.
Judge, he's here present at me.
Thank you. Hello, Mr. Stroman. Mr. Stroman, you're here on a violation of parole as well. There's currently a no bond hold, but you will be picked up to deal with the violation. So good luck to you, sir.
Judge, my understanding in speaking with Mr. Sherman, he advised me he has 4 weeks left on his, I guess, parole.
Okay.
He's going to be asking the court if Your Honor could do anything for him.
As far as what, sir?
Saving my job.
Okay, the court can't save your job for you, Mr. Stroman. Right now, you were picked up on a violation of parole. You're gonna have to address that matter, and that's not before this court. I'm sorry.
Yeah.
Good luck to you. Anthony Castellan?
Mr. Castellan, come up.
Hi, Mr. Castellan.
Hello, how you doing, Judge?
I'm well, thank you. Mr. Castellan, you're here on a burglary of an unoccupied structure, grand theft, dealing in stolen property, and false ownership of pawned items charges. The court does find probable cause. I'm setting bond on the burglary charge in the amount of $1,000. You have a $1,000 bond on the grand theft, $3,500 on the dealing in stolen property, and another $3,500 on the false info for pawned items. So it's a total of $9,000.
Yes, ma'am.
Good luck, sir.
We're going to be asking for, just on counts 3 and 4, we understand Your Honor set a $1,000 bond on 1. He has a $1,000 bond on 2. He currently has a $7,000 total bond 3 and 4. We're going to be asking for a bond reduction to $1,500 on 3 and 4. If the court were to impose that, my understanding would be a total of about $5,000. He called his roommate. He believes his roommate can come up with the premium with the bondment of $500. That's all he really has right now. Mr. Castellan, he's a boxer. Unfortunately, in the year 2017, from what he advised me, he made about $7,000 for the year. So right now, he lives in Oakland Park. He lives with his roommate. His roommate's basically supporting him. He's been here his whole life. He's 24 years old. My understanding is his only prior, I guess, convictions or anything like that is misdemeanor offenses. So, Judge, we'd be asking you for a bond reduction just on counts 3 and 4 to $1,500 on each count.
Okay. What is the state's position?
Your Honor, we would ask that you keep the bonds you set in place. The state was actually going to be asking for a bond increase on count 1, even though it's charged as a burglary structure. It really is a burglary of a dwelling, as this was a carport that was attached to someone's residence. So it's a little bit more concerning, and could be a secondary felony. So in balancing those two matters out, we're just requesting the bonds be kept in place. And also that the court order no victim contact, no return to this residence.
What kind of priors does Mr. Castellan have?
I'm showing right there a resisting without violence last year. Just traffic other than that.
Okay. The court's going to grant your request. I'm going to reduce the bond on count 3 to $2,000, reduce the bond to count 4 to $2,000, so it's a total of $6,000. The court's going to order no return to the subject property and no contact with the alleged victim, sir. Kevin James Parks.
Mr. Parks is here presently.
Hello, Mr. Parks.
Hello.
You are here on 7 counts of dealing in stolen property and 1 count of false ownership info for pawned items. The court does find probable cause. I have to add up your bond amount because you have $3,500 on each dealing in stolen property and then the same on the false ownership. Let me tell you what the bond is. It's $31,500.
Yeah. Did you go on all the pages?
Oh, he's got more?
Yeah.
Oh, I'm sorry.
I think it's 38.5.
I'm sorry, Mr. Parks, I misspoke. You have a second page with charges 9 through 14, another false info, ownership info for pawned items, grand theft, 2 more false owner info for pawned items, and 2 violation of probation. So the total amount of bonds is, hold on. I have $43,000.
I have, wait, 1 moment.
But there's a no bond hold on his violation of community control.
Yeah, I have 39.5. It's 11 counts at $3,500 each plus 1,000.
Okay. All right. I'm being told your bond set at $39,500, but you do have a no bond hold on your probation violation.
Judge, considering as a no bond hold on his VOPs, we'd be deferring any future arguments for a bond reduction at this time.
Okay, he does have a court date on June 11th at 8:30 in the morning.
Thank you, Judge.
He's also asking for no victim contact.
The court's going to order no victim contact in all the cases.
Yes, Judge.
Okay, good luck, sir. Alan Christopher Catalyst?
I believe it's a medical loan, Judge.
Medical reset, you said? Okay, we'll reset in. Kenneth Procyse? Thank you. Hello, sir. Mr. Procyse? You're here on a burglary of an occupied dwelling and corruption by threat charges. The court does find probable cause. I'm setting bond on the burglary charge in the amount of $2,500, and on the corruption by threat, bond is set at $1,000. The court is ordering no contact with the alleged victim and no return to the subject property.
Your Honor?
Yes, sir.
The state would also, in addition to the bonds you said, we would be requesting pretrial release with a GPS monitor. Mr. Precise just got out of state prison March 21st of this year. He was sentenced to a year in day state prison on a 2016 case out of Broward for burglary, attempted burglary of an occupied dwelling, and battery of a law enforcement officer. He's also gone to prison for grand theft auto, resisting an officer with violence, and possession of controlled substance.
Okay, so you want the additional order for him?
GPS level 2.
Yeah, Mr. Pros is not going to be able to make that bond under any set of circumstances, Judge. I am going to contact his family to see if they can help him out in some way. All right, Kenneth?
Okay, so Mr. Process, what the court's going to order based upon your prior history, the court's also going to impose that you are monitored by pretrial release on level 2 if you post the bond. We have a GPS monitor.
Oh, okay.
All right, but the public defender is going to be in touch with your family.
So you can't just put me on pretrial release?
No, sir.
I have to get back to work.
The answer is no. Good luck. Henry Eluit?
Mr. Lewis is here present, Judge, on me.
What? Yeah, plus the bond. You're welcome. Okay, hello, Mr. Lewitt.
How you doing, Your Honor?
I'm well, sir. You're here on a robbery charge and illegal use of a credit card. The court does find probable cause. I'm setting bond on count 1 in the amount of $5,000 and count 2 in the amount of $1,000 for a total of $6,000.
Judge, and speaking of Mr. Alut, he's 18 years old. At this time, unfortunately, he's not employed. He's going to summer school at Whittam Rogers. He lives in Fort Lauderdale with his mother. Right now, from what he informed me, there's no one that could post a monetary bond for him. We're going to be asking, and we understand the nature of the allegations, so I'm going to be asking you to consider releasing Mr. Alut on level 2 pretrial release with a monitor. That's our request, Judge.
Okay.
He's being add charge with additional charges after.
Also, he has violent priors as a juvenile.
He has priors?
He has priors, including violent priors as a juvenile.
Okay. Okay. I've been advised that there are going to be ad charges that are going to be filed against Mr. Aluit. I am not going to adjust the bond.
Yes, Judge, thank you. Let me explain that to him.
Okay, thank you. Daniel James Shaw?
Your Honor, before you move on, the state would also like to add no victim contact. So, Mr. Ewart.
Okay, Mr. Hewitt, no victim contact.
Hector, do you have him come back?
Come back, sir.
Sir, you'd have no victim contact.
Yes, ma'am.
Okay.
Judge, he's asking me, is there any idea what the additional charges are going to be?
The answer is no?
I don't think they know. I don't think anyone in the courtroom knows at this point.
Okay. It hasn't been determined yet. All right, Daniel James Shaw?
Mr. Shaw, come on up.
Hi, Mr. Shah.
Yeah, how you doing,
I'm well, thank you for asking. Mr. Shah, you're here on an aggravated battery of an officer. You have a distribute or deliver cocaine charge, 2 counts of distribute or deliver heroin, and a fleeing charge. The court does find probable cause. I'm setting bond on the aggravated battery in the amount of $7,500. I'm setting bond on the fleeing in the amount of $7,500, and bond on the remaining charges is $7,500 total. So you have 20, hold on. It's a total of $22,500. The court's ordering no contact with the alleged victim.
And speaking with Mr. Shaw, and he's been residing in South Florida his whole life. He's 28 years old. At this time, he is looking for employment. He was previously working. He was working at a warehouse where he made about approximately $10 an hour. I do understand he does have priors. However, from what he informed me, he has no failure to appears. He's going to be contacting his cousin to help post his bond. His cousin works at a daycare facility, so she can't come up with much. So I'd be asking you to consider posting a bond as far as $1,000 on count 1, $1,000 on count 5 into ROR 2, 3, and 4, and besides that, Judge, placing him on pretrial release so that there's a monetary bond and he'll be under supervision considering everything. We're asking that the court do that, Judge.
What's the state's position?
Sir, the states believe that your offer was reasonable because this is a first-degree felony punishable by 30 years in state prison.
Based upon the nature of the allegations that I'm reading in the complaint affidavit, the court is comfortable with leaving bond as I said.
Yes, Judge.
All right. Brian McCroskey.
Mr. McCroskey, come on up, please.
Hi, Mr. McCroskey. Okay, so Mr. McCroskey, you're here on a burglary of an unoccupied dwelling, a burglary of an occupied dwelling, 2 criminal mischief charges, and a capias. And I need some assistance from the state on the burglary of an unoccupied dwelling and the criminal mischief of $200 to $1,000. It seems to me, looking at the complaint affidavit, I don't see where there are 2 separate counts of burglary or 2 separate counts of criminal mischief. Could you explain to me where that is? It looks like the victim observed the defendant enter a fenced-in yard. She heard the side gate of her home swing open. She confronted the defendant. She observed a small garbage can destroyed. And that was it, from what I see here. Okay, so the court does not find probable cause on its count 2.
Yeah, and just as far as the 2 counts of criminal mischief, I imagine one is for the garbage can, the other is for the.
Okay. Okay, so Mr. McCroskey, the court does not find probable cause on count 2, the burglary of an occupied conveyance charge. Does the state wish time to perfect? Okay, so that's going to be an ROR on count 2. On count 1, the burglary of an unoccupied dwelling, the court's going to set bond in the amount of $1,500. And you currently have, on the capias, it's a $1,500 bond, and then $125 on the criminal mischief charges. So it's a total of $3,125. Good luck, sir.
Thank you, Judge.
And no return to the property. Jerqueen Brown?
Mr. Brown, come on up, please. Mr. Brown? Queen Brown. He's approaching, Judge.
Okay. Hello, Mr. Brown?
Good morning.
Mr. Brown, you're here on a possession of cocaine charge, possession of cannabis, drug paraphernalia, and tampering with or fabricating evidence charge. The court does find probable cause. Bond is set at $2,200.
Judge, we're going to be asking Your Honor to consider releasing Mr. Brown on pretrial release. Right now, he's 24 years old. He's been here his whole life. He has a job. He just got a job 6 months ago at a call center. He's making about $200 per week. Unfortunately, right now, he's going through a tough time. He is homeless. My understanding, though, Judge, he has a mailing address. He can receive mail at his grandmother's, so therefore, notice will be sent, so he'll be able to appear for future court dates. So, Judge, I'm going to be asking you to consider these are drug offenses, nonviolent in nature, Judge, for you to consider releasing him on pretrial release.
Okay. Does the state have any objection?
Yes, Your Honor, the state objects.
And tell me why.
He's out on a $2,100 bond on a tampering with evidence and possession of cannabis case 18.
Is that a different case?
Yes, yes, Your Honor, it's a pending felony. And he has a pending misdemeanor as well.
Okay, so he picked up these charges while he's out on bond on pending cases.
Yes, Your Honor.
Okay. The court's going to deny the request to release him to pretrial. He's not a good candidate based upon what I'm hearing.
Yes, Judge. What she said.
Timmy Lee Brown.
Mr. Brown, come on up, please.
Hello, Mr. Brown.
Good morning.
Mr. Brown, you're here on a possession of cannabis and possession of MDMA charges. The court does find probable cause. You do have bonds set at $1,000. And let me ask the state, do you have any objection to releasing Mr. Brown to pretrial?
Judge, in speaking with Mr. Brown, he gave me the phone number to his friend, Linda.
Yes.
I'm going to be calling her after court so she could post his monetary bond.
Oh, okay. All right, then he's all set. All right, good luck, sir.
Judge, right now, Mr. Brown is whispering to me. He gave me the phone number of Linda. He doesn't know if Linda's going to be able to afford it, is what he's telling me right now. So I guess I apologize, Mr. If Your Honor is inclined to do pretrial release, I would assume that's the 100% safest bet he'll be able to be released. So
Okay,
I
so
don't know if the state has an objection.
let me find out from the state.
Just a minute, Your Honor.
Okay.
And then has
That's it.
over 32 prior arrests.
Yeah, it's 2/3.
I see the 32.
So we were, Your Honor, he does have a lengthy record. He has 2 failures to appear. It's, on the third-degree drug case, if the court's okay with it, we're okay.
Okay, the court is going to refer Mr. Brown to pretrial release.
Thank you, Judge. And he'll have to report within 24 hours?
Yes, he does.
There's the map, and that's how you get there. As soon as you get released today, you go there today. If they're already closed, you go there tomorrow before 12 noon. Yes. Good luck, sir. Go.
Robert Earl Holloway.
Mr. Holloway, come on up, please. She's approaching, Judge.
Hi, Mr. Holloway.
How you doing, ma'am?
Well, thank you. Mr. Holloway, you're here on an arrest warrant for uttering a false instrument. There is currently a no bond hold, but you will be appearing before Judge Shearer to address this case.
Judge, he is entitled to bond on this charge, and it's a warrant.
Oh.
Judge Shearer was just on duty that week. The case isn't assigned to her.
Okay.
Legally, she sent in a no bond to ensure that, for the arrest, but he is entitled to a bond.
Okay. All right. So what does the state feel is appropriate for Mr. Holloway for bond? count two is the MDMA. He's going to pretrial on both counts. You're welcome.
Your Honor, the state is asking for $2,500 based on the fact that he has 16 prior felony charges and he's been in state prison as well.
Okay, does the public defender wish to be heard?
Yes, Judge, we're going to be asking for 1,000. My understanding is Mr. Holloway is at this time not working for medical reasons. He lives with his mother. His mother is a caretaker. He believes that she can come up if the bond were set at $1,000. If not, unfortunately, he's going to be remaining here with us at the Broward County Main Jail. Like I said, he's 51 years old. And also one other thing, Judge, he doesn't, I believe this is not in custody of capias. He doesn't know when the alleged date of incident is. We would like to know when's the alleged date of incident as well.
It says February 26, 2018.
Your Honor, just so the court's aware, if the court does set the bond at $2,500 or any bond amount, and Mr. Holloway does not post bond, he, per administrative order, will come back for a second look review.
Okay, the state was asking for 1,500.
2,500.
2,500.
Yes.
Okay, and the public defender is asking for 1,000. The court's going to set bonds at $1,500. Good luck, Mr. Holloway.
Thank you, Judge.
You're welcome. Stephen Lamar Edwards. Hello, Mr. Edwards.
Good morning.
Ms. Edwards, you're here on a grand theft auto charge, a no valid license, and you have a traffic ticket. The court does find probable cause. You have a $1,000 bond.
Judge, we're going to be asking Your Honor to consider releasing Mr. Edwards on pretrial. I'll see if the state has an objection before I make further argument.
Okay, state, do you have an objection?
Just a second, Your Honor. Your Honor, the state objects, Your Honor, because he has a lengthy criminal juvenile record and he has a prior pickup for absconding, Your Honor.
Okay, the court's not going to refer him to pretrial under the circumstances. I'm going to leave a $1,000 bond.
Yes, Judge, thank you.
You're welcome. Ronald Charles Shepard.
Mr. Shepard's here.
Okay, hello, Mr. Shepard. I need one moment. Okay, so Mr. Shepard, you are here on 5 counts of fraudulent use or possession of someone else's ID, and you have a capias in a misdemeanor case or traffic criminal matter. The court does find probable cause. You have bonds set in the amount of $5,500.
Judge, what we're going to ask you to consider is a bond reduction. We're going to ask you to leave the bond in place on counts 1 and 2 and ask you to consider an ROR on counts 3 through 6. He's 34 years old. He's been here his whole life. Right now, he's a painter, but unfortunately, he hasn't gotten paid in a while. He's basically subject to weather, so whenever there's forecasts of rain, they can't take the risk of painting. So I believe the last time he was able to work was this past Saturday. He lives in North Lauderdale with his sister. His sister does, like, I believe, customer service, making minimum wage. So he believes his sister can come up with the premium, with the bondsman for counts 1 and 2, but he doesn't think she can afford anything else. So that's why we're requesting what we're requesting, Judge.
All right, let me hear from the state in response to that request. They're asking for a ROR on counts 3, 4, and 5.
I thought, was the request also for count 6?
Well, count 6 is a capias.
Yeah, no, we were, Your Honor.
No, capias, I know your hands are tied, Judge. No, we're not referring, I apologize, not on 6, on 3, 4, and 5.
Okay.
The state has no objection, Your Honor.
Okay, the court's going to grant your attorney's request. I'm going to reduce bond on counts 3, 4, and 5 and RORU on those 3 counts. So your bond now is $2,500. You're welcome. John Robert Galliano.
Mr. Galliano, bonded, Judge.
Okay, thank you. Nicholas Cromedy.
Mr. Cromedy?
Hello, Mr. Cromedy. Mr. Cromedy, you're here on a criminal mischief charge, burglary of an unoccupied conveyance, another criminal mischief, and another burglary of an unoccupied conveyance. The court does find probable cause. The court is setting bond on each of the burglary charges in the amount of $1,000. So your bond is $3,000 total. And the court's ordering no return to the subject property.
Judge, we appreciate, as far as normally this would be reasonable, but unfortunately, Mr. Committee advised me there's no one that's going to be able to post his bond, so we're being asking for pretrial release. First, I'll see if the state has an objection.
Does the state have an objection?
The state has no objection, Your Honor.
Okay. Then, under the circumstances, Mr. Cromedy, the court's going to refer you to pretrial release. Nicholas Cromedy.
Thank you, Judge. And you have to report within 24 hours?
Yes, he does.
That's standard pretrial supervision? It's standard, correct, Your Honor?
Yes,
You're not putting them on.
standard.
No bond requirement.
That's correct.
Thank you, Judge.
There's no return to the AutoNation Nissan dealership?
No return.
Pembroke Pines?
Okay, the court already advised to no return to the property.
Okay, sir. You can take care, okay? Good luck with applying to Broward College, all right? Good luck.
Martin Javier Mendez.
He's approaching, Judge.
Thank you. Hello, Mr. Mendez.
Morning, Your Honor.
Mr. Mendez, you're here on possession of GHB, possession of methamphetamine, drug paraphernalia, and you have a capias on a misdemeanor case. The court does find probable cause. You have bonds set in the amount of $2,150.
Judge, we're going to be asking if Your Honor would consider an R warrant counts 2 and 3. I'll see if the state has an objection to that.
No, Your Honor. No objection.
The state does not have an objection. The court's going to grant your request. You have bonds set in the amount of $1,050.
Good luck, sir.
You said for the record, what are you are on?
On count 2 and count 3, he's being ROR'd. You're welcome. Jonas Cerruti?
Judge, he's here present. My understanding is he has a private counsel on this case.
Okay, thank you. Mr. Cerruti, do you have a private attorney?
Sorry, ma'am?
Do you have a private attorney?
I just have, I called my lawyer when I was getting arrested. That's all.
His bond's been posted.
Oh, okay. I'm being told that your bond has been posted.
I'm sorry, ma'am?
Your bond has been posted. You're going to be released.
So,
Somebody posted your bond.
This is my first time with everything. I don't know what's going on.
You're getting out of jail, your bond's been posted.
You're going to get out of jail. Somebody posted your bond.
Okay, is it, because my lawyer said that he said that he was going to... Okay, I'm sorry.
Sir, you're going to be released today.
Okay, I'm sorry. Thank you, Miss. Thank you, Miss.
Thank you. Martise Terrell Pointer.
North Broward, Your Honor.
Thank you. Medical reset? Okay, we'll reset her for tomorrow. And that seems like that's all we have.
Judge?
Yes.
Judge, what time are we going to start this afternoon?
We're going to start at 1:30.
Thank you, Judge. Appreciate it.
You're welcome.